Hi, I'm Chris Mammen. I'm the founder of PARC and In the House, and those are communities for law partners and in-house counsel, respectively, for professional networking and career and business development purposes. On the third Friday of each month, we have a guest speaker, which is either someone from one of our communities or from outside who's talking on an interesting topic that we hope many lawyers would be curious about. I'm really excited today to have Chris Mammen as our featured speaker. Chris is has been an intellectual property lawyer for many years, and he's going to be speaking today on the topic of how AI is changing the practice of intellectual property law, and also who can potentially be inventors, who or what can be inventors or creators under patent and copyright law. So Chris, I wanted to invite you, first of all, just to introduce yourself a little bit, talk a little bit about your work and your background, and then you can get started with your presentation.
Good.
Great.
Do you know where
Yeah, and
mommy?
I think you may want to mute everybody else. All right. Thanks very much. As Chris mentioned, I'm an IP litigator out in San Francisco and Silicon Valley. I've been out here for about 20 or 25 years. And I'm really excited about this topic because it's one of the few things that comes along that allows me to blend my background in IP litigation with my background in legal philosophy, and raises some terrific questions sort of at the intersection of that. I've actually been litigating a number of sort of AI related cases lately as well in the areas of speech recognition and so forth. So this is something that has tremendous practical value as well. Why don't I go ahead and pull up my slides, and I've got a little, it says host disabled participant screen sharing.
There you go. I just made you a co-host. I was a little slow on the trigger. Sorry, Chris.
Okay. So let me share that and then convert this to presentation mode. All right. So as a icebreaker, I'm not going to focus that much today on copyright law. I'm going to focus mainly on patent law because that's where the law has been really developing just in the past couple of weeks. But as an icebreaker, I thought I would start off with some illustrations of the kinds of AI created art that we're seeing, and that raises some questions about copyrightability. And so I'll just leave you with some of those questions. So we start off and take a look at these. For those of you who've taken an art history class or two, you can spot which one is AI created and which one is created by a human. This one's pretty easy. The trippy picture of the Duomo in Siena with animal faces in it is clearly AI created. This one, a little more difficult. And I'm not, from here on out, the next couple, I'm not going to give the answers just because I want you to be sort of experience the uncertainty about knowing what is human created and what is AI created. And then last, we get this one. So one of these is a real Rembrandt. One of these was created by an AI. So a much more difficult call than the trippy cathedral with animal faces. And so actually, in this picture, the man is the one that was AI created. The closest thing in Rembrandt's works is this portrait of a musician from 1633. This other one was created by a specially developed algorithm called nextrembrandt.com. It took all of Rembrandt's photos, put them all into an algorithm, and then used those to generate a picture. And so this raises some questions. Can this picture be copyrighted? If so, who is the artist and who should own the copyright? These are the kinds of questions that come up in the copyright side of this context, and some really interesting questions that come up out of that. And believe it or not, a lot of the issues actually fold back to the famous monkey selfie case, and whether or not the monkey in this photo could own copyright in this picture. And that was heavily litigated 4 or 5 years ago. So with that little intro, I'm going to switch now and talk about patents. And really, for the past 3 years or so, we've been talking about AI inventions broadly. And what I want to do is I want to start off by dividing this into 3 categories. One is where the AI is the invention. That is, you know, we were talking at the start of the call about things like self-driving cars. You know, where the algorithms are the thing that you've invented that enable us to do something else. And there are some challenges to that, and I've got some listed in the sub bullets here. There's another where AI helps a human inventor, and for ages, we human inventors have used tools to help us in the research and invention process. Sometimes those tools are physical things like test tubes or scales. They can also include computers, increasing in sophistication over the years. And sometimes there are lab assistants who maybe don't contribute enough to the research process to themselves be named an inventor, but who are humans who have participated in the process. And so, you know, where an AI is used in that context, is it just another technology tool, or should it rise to the level of being a co-inventor? And that leads us to the third category, which is the one we're going to talk about today, which is where the AI is the inventor. You know, what are the legal restrictions and what are the conceptual limitations on naming an AI as the inventor on an invention? This comes up in a variety of contexts. You know, a couple that are really actively in use right now: drug discovery, using algorithms to construct electronically all kinds of different molecules and apply known biomedical information to them in order to figure out whether there may be good new drugs. Algorithms are also being used to design new circuits that are different than the ones that humans have previously designed. Lots of areas where these kinds of things are useful. It's tempting, as we talk about all of that stuff and as we read the headlines, to jump right into the policy discussion and you know, jump to the last question: should they or shouldn't they be allowed? And that's a fun thing to debate, but in order to get there rigorously, it's helpful to go all the way back to first principles and see what we're limited in talking about. So in the US, both copyrights and patents are governed by and empowered by Section 8, Clause 8 of Article 1 of the US Constitution, which refers to authors and inventors and providing rights to authors and inventors. So constitutionally, we can only give patents where there's an inventor. So what does inventor mean? Well, we look at the Patent Act, and it defines an inventor as the individual who invented. And elsewhere in the Patent Act, it refers to whoever invents, and says a person shall be entitled. So we have these words, you know, individual, who, person, and we need to decide whether whatever it is that an AI happens to be, does it fit within the legal meanings of these terms? If it does, then it may be authorized, but if not, then our existing laws preclude application to an AI context in the US. this is just the first of a number of questions that patent lawyers love to wrangle with. So we're talking today about, can it be an inventor? There are some practical reasons why arguably the AI's programmers can't be the named inventor. But then also, an invention, a patentable invention, has to be novel and non-obvious. But if you're applying this at the level of something that's got the breadth of knowledge of IBM's Watson that was able to win on Jeopardy, what's not obvious to Watson? Does this change the level of obviousness? Do we end up with a dual standard of obviousness to humans for human created inventions and obviousness to computers for algorithmically created inventions? So a lot of these kinds of fun questions. There are other ways, other corollaries as well. Even if we have human created patents, can we use the AI algorithms to connect the dots and show that everything is obvious? What if an AI can be an inventor, can it also be an infringer? Is it just on one side of the equation of protection and enforcement of AI, or can it be on both sides? What would it look like to accuse an AI of infringement? These are questions that are sort of beyond the horizon right now. So let me turn now to talk a little bit about why we're talking about all of this. There's this group called the Artificial Inventor Project that's led primarily by a computer scientist out of Missouri named Dr. Peter Thaler, and a professor based out of the University of Surrey in England named Ryan Abbott. And Dr. Thaler has written an AI algorithm that he turned loose and he claims has come up with a couple of very useful inventions that should otherwise be patentable. One of them is what he calls a fractal container, and the other one he calls a neural flame. The fractal container, which is described in words here, looks like this. So it's basically a cross between a throwing star and a soda can. And then the neural flame is a particular sort of light signal that flickers in a fractal inspired pattern to draw enhanced attention to search and rescue teams. These are the two applications that the Artificial Inventor Project has filed patent applications on in over a dozen countries. And really the only two patent applications I'm aware of where it's exclusively claimed that the AI and no human is the inventor. The question is, I think, pretty conclusively resolved in the US and has been resolved since the 50s. Long before AI even came into being, that case law has uniformly held, consistently held, that an inventor under US patent law has to be a natural person, a human being. There may be some question about, well, these cases only came up in the context of humans versus corporations, but there's perhaps even the argument that an AI should be an inventor if a corporation can't is even more of a edge case, farther out case than the question of whether a corporation can.
Hey, Chris, do you mind if I just ask you a clarifying question if you know the answer?
Sure.
Do you know, number one, whether the US Supreme Court has ever dealt with this issue, even tangentially, and also the courts that have dealt with it, was that a matter of constitutional construction or construction of the Patent Act, if you recall?
That's a great lead into the next three slides.
Okay.
The one place that we can look at to construe the statutes, and recall the Patent Act uses the word inventor and individual, and so those cases were interpreting. There was a federal circuit case and a court of claims case that were interpreting the statutory language. The Dictionary Act provides two definitions here, one in section 1 and one in section 8, that seem to be a little bit circular, but really don't don't fully resolve the question. They're enough to support a hypothesis that, if we've got a Venn diagram, the big circle is person, within that is individual, and within that is human. But that's sort of a hypothesis at this point. So there's a question of how else have the courts addressed this question, whether individuals are limited to natural persons beyond those two cases that I cited from the Federal Circuit and the Court of Claims. So the word individual appears in a variety of statutes. Supreme Court has weighed in the Torture Victims Protection Act to say, yes, it's individuals only. Freedom of Information Act, Ninth Circuit has said yes. Other courts in various contexts, particularly the Bankruptcy Act and statutes protecting crime victims, and in particular damage to computers, have given a broader interpretation to individuals. So it's not out of the question that individual could be defined somewhat more broadly than natural persons. It just depends on context. So, the point at which all this came up was in the summer of 2019. There were a bunch of headlines because more or less simultaneously, the US Patent Office, the UK Patent Office, and the European Patent Office all said no. The fractal beverage can and the neural flame could not be issued as patents in those jurisdictions. Shortly after that, the UK changed its formalities manual, the equivalent of what we in the US refer to as the Manual of Patent Examining Procedure, to make clear that an AI inventor fails to identify a person. And so that's kind of where things were. As of late 2019, these three major jurisdictions had said no, and nobody else had weighed in. The reasoning was much like what we've covered here. Statutes require that an inventor be human. Case law requires it. Sometimes there's failure to satisfy formalities. In the US, you have to submit an oath of inventor that's sworn under penalty of perjury. How does the AI sign under penalty of perjury? How does the AI sign? So, there's those kinds of questions. If Thaler is filing the application, how did Thaler get his rights from this AI? By what operation of law or fact did any rights that resided in the algorithm Davos get transferred to Dr. Thaler? And some of the patent offices also talk about how the act of invention requires a theory of mind, and only humans have minds, and sort of going down that path. So that's the sort of the supporting reasoning. Objectors have said, very sort of chicken and the egg. If Thaler put his own name down on there, that would be fraudulent. We shouldn't make him commit fraud. Or if you have an invention, then you have to have an inventor. And if there's no human inventor, then you got to change the law to allow whatever the inventor is to be named as the inventor. And then there's an economic theory argument that says rather than viewing IP law as some sort of policy aimed at enhancing human flourishing, it's really a matter of economic competitiveness in the global economy. And so as a matter of industrial policy, we should be protecting whatever's innovative, regardless of however it came about. That was kind of the state of affairs until the last 2 months. And then in August, the IP office, the Patent Office of South Africa, agreed to issue a patent owned by Thaler on these Davos inventions. The next day, the a court in Australia likewise held that those applications should be deemed patent eligible. A couple of weeks later, Judge Brinkema in the Eastern District of Virginia, ruling on the previous U.S. Patent Office ruling, affirmed that no, there shouldn't be AI inventor patent eligibility in the U.S. And then about 3 weeks ago, the UK Court of Appeal weighed in, also saying, but more ambiguously, no, an inventor in the UK has to be a human. And I'll talk about why why that's ambiguous and why there's some interesting open questions. So why did South Africa and Australia reach these different conclusions? Part of it was in South Africa, inventor was not defined by statute as being a person or an individual or anything like that. And they don't examine the patents down there. It's more like copyright registration or trademark registration. They may also, there's a lot of discussion in South Africa about changing the patent laws to serve industrial policy. So this may have been a move in that direction as well. The Australian one is a little more puzzling because inventor is defined as a person there. The court held it wasn't prohibited, but it made a whole bunch of assumptions, which I've outlined on this slide. The assumptions that the AI sets its own goals, that the AI has freedom of choice to choose between options and pathways, that the AI chooses the input data, the AI is autonomous, and the AI has the AI has all of these choices, and that in fact Dabus had all of these choices, and that I think is a set of assumptions that goes well beyond what Thaler and Abbott would even claim. So this paragraph really jumped out at me in the Australian court's ruling. The Eastern District of Virginia ruling held that inventors must be humans under the case law, under the definition of individual, relied on that Supreme Court ruling that you asked about, Chris, and then said, because we've got such a clear legal doctrine, we don't even have to talk about any of these policy issues. That case is now on appeal to the Federal Circuit. And then, as an add-on, I would note that on the Artificial Inventor website, they have made clear they don't contend that their AI has legal personhood. So it's a little bit puzzling to me how under statutes where an inventor must be a human or must be a person or an individual, how they can claim a right to inventorship. So finally, there's the UK Court of Appeal ruling, which was so complex that I had to put in a table here. It was a 2-to-1 ruling. And the reason it's complex is because in the UK, you're required to fill out a form. The applicant's required to fill out a form that identifies the inventor if they know who it is. But if that space is left blank, you can still get a patent theoretically. And so, the conclusion here was, well, Thaler put Dabus in that inventor slot, and that was wrong. And so his application was canceled. And so, for that reason, that application is dead. But then there was this other question about the legal doctrine of accession, of how is he entitled to file the application? Accession is the notion that if you own the apple tree, then you also own the apples that grow from the tree. It goes all the way back to Blackstone. And so these judges in the UK, Court of Appeal judges, were citing and discussing in depth Blackstone, 17th century jurisprudence, in order to figure out whether intangibles like an invention that's output from a computer algorithm is the same thing as an apple that grows on a tree. One judge said no. One judge said yes. And one judge, Judge Lang, kind of went along with the judges and said, no, they're different. And so by 2-to-1 ruling, the Dabus doesn't get its patents in the UK. But there's this question of what if Thaler went back and filed a new application, instead of saying Dabus is the inventor, said, okay, you've now told me that an inventor has to be a human. Given that definition, I don't know who the inventor is. but I own the computer system, so I should get the patent. Judge Burse would say, yeah, that's good for me. Judge Arnold would still say no, because the invention is not an apple from a tree. Judge Lang, it's not clear. I think there's a non-zero chance that that kind of approach could work in the UK. As I mentioned, and the Federal Circuit appeal is going, and there are about 10, 12 more countries where applications are still pending, where there hasn't been a ruling yet. So there's going to be plenty more to come. And I know that was a lot more than 15 minutes, but I'm happy to take questions now.
Yeah, thank you so much, Chris. I think I'd like to wrap up the recording so it's not too lengthy. But I did want to thank you for your time today, and also for the people that are watching on the video later. Would you mind sharing your how people can contact you if they have questions about this or want
Sure,
to reach out to you for another reason?
I'll put it in the chat.
Okay, perfect. Okay, so Chris will put that in the chat. And then also you can reach me, anyone can reach me at chris@inthehouse.org. And I'd be happy to answer any questions about how to contact Chris and see if I can arrange for that. So thanks again, Chris. I'm going to wrap up the recording, but really appreciate your time, and then we'll stay on the line for Q&A.
All right. Thank you, Chris.